All right. So, right. Okay. So our sharing as based on the SharePoint updates. Okay. For those who have not who are new here, this is the SharePoint updates. Okay, that you see on the screen. Which we will circulate on a weekly basis. The last one is on July 22nd, which is last Thursday. Okay, highlighted one of the case, which is the first that you see here. Okay, Shuntit paper boxes manufacturer Sdn Bhd against Tasker 021 High Court case. Okay. All right. So today we will zoom in this case. Okay, so I will share another slide. Okay, I will share another material. Okay. Okay, so questions or clarification that you might want to be asked. Okay, so we will go slowly. Okay, based on the facts and what is the issues, what happened. Okay, let's go to the facts of the case. In this case, plaintiff enter into sale and purchase agreement with the first defendant. Okay, so plaintiff here is the purchaser, and the first defendant is the vendor. Okay. So both are companies, plaintiff and the first defendant are companies. They enter into SPA on 1st November 2017.
Ms. Poyi,
yes,
sorry to interrupt. Can you put in presentation mode?
Presentation mode.
Presentation
what
mode.
does that mean?
Okay, you click. You see down there. There is a button. Presentation slides button. You bring your mouse to. Okay, you see 72% the scale. Okay, yes. You click there. Yes, correct. Click the button.
Is it slideshow one?
Yes, correct.
Slideshow like this, is it?
Correct. Okay.
Is it like this?
Yes.
Okay. Okay, everyone can see. Everyone can see. Yes. Okay. Yes, Maizato. You want to speak something?
No, now it's okay.
Maizato, you want to speak something, is it?
No.
Okay, just now where did I stop?
Okay.
No means what? Sorry.
No, okay, you can proceed.
Okay, I will proceed. I will continue. Okay, just now we stopped at both plaintiff and the first defendant enter into sale and purchase agreement on 1st November 2017 to purchase a piece of land in Batang Kali, Selangor. So for 1.7 million. Okay, so the as I said, both entities are companies. So the sale companies then are fixed by the respective directors, okay, of both plaintiff and first defendant. So on the part of first defendants, the common seal was affixed by two of its directors, okay, named Ravi and Kalai Selvi. Okay. So these Ravi and Kalai Selvi are nationals of India. They are Indian citizens.
Oh, you cannot hear, Boyi.
Their appointment as directors of first defendants are actually in question. Okay, which we will go detail. Okay, why is in question later. So the second defendant in the select, you're not here. Maybe the line is not good. Hello, can you hear me now?
Yes, Boyi.
Okay. If you can't hear, then let me know. You have to tell me. Okay, just now we continue. Okay, these two directors of the first defendant, Ravi and Kalai Selvi, okay, are citizens of India, and their appointment were in question, which will go later detail. So the first defendant appointed second defendant, which is a lawyer, to represent the first defendant in the sale and purchase. So meanwhile, the plaintiff also appoint its own lawyer, Mrs. K. Lim and Kong, for the SPA. So both parties are represented. So the plaintiff paid 10%, 171,000, okay, to second defendant as the stakeholder. So that sum was released by the second defendant to, not that sum, okay, 137, part of that sum, okay, to Ravi, okay, right? So on 31st November, okay, so this, can't really see. Okay, the plaintiff solicitor then suddenly received a letter from another lawyer firm, okay, Sundramurti and Company, so informing that the sale purchase is null and void. So the two directors who attested that the common seal on that SPA were appointed as directors without knowledge of other directors of the first defendant. Okay, so the plaintiff solicitors wrote to the second defendant, okay, who was representing the first defendant in the SPA, to seek clarification. So the second defendant replied on 9 March, okay, 2018, that he could not get instruction from the two directors. So plaintiff appointed, okay, another lawyer firm, Yap Siu Yi and Company, to demand the first defendant to complete the sale and purchase. So there's no response, okay, from the second defendant. Next slide. Okay. So because there's no response from the second defendant, the plaintiff informed the first defendant that in absence of its response, it would be considered a breach, okay, of the terms of the sale and purchase. So then later, still no response, the plaintiff terminated the sale and purchase. So and remanded demand for the refund of the 10% paid together with agreed liquidated damages, okay, at 10% of purchase price. Okay. So they filed a suit to claim for that, and the first defendant, of course, they will raise defense saying that the sale and purchase was null and void because the two directors, Ravi and Kalai Selvi, who attested the sale and purchase, were not validly appointed because okay, as directors of the first defendant, because their appointment was without knowledge of the first defendant. Okay, in fact, the documents lodged with the sale and purchase, with the SSM, okay, for the appointment of directors were forged and unauthorized by the first defendant. That's the defense of the first defendant. As a result of their valid appointment, the sale and purchase is not valid and not binding on the first defendant. Okay, that's the defense.
Yeah.
Okay, so naturally the issues is tried. Okay, for trial is invalid and binding. Okay, on first defendant. Okay, so what's that? Someone speaking there? Okay, so what's the court finding? Okay, after full trial and seeing the documents, okay, filed by the parties in the court. So the issues to be tried just now. Okay, so we need to know whether we need to answer Ravi and Kalai Selvi as directors of defendant's knowledge. Okay, and answer whether the SPA is valid or not. So for the first defendants come cut off. Okay, I have to reconnect it. Okay. Okay, so from the evidence of the court, find that the first defendant's company secretary, okay, he issued a letter, okay, that at that material point of time, the company secretary was another person, which is Ravindran. Okay, he's the one signing on the cover letter to lodge with the documents with SSM. But he later resigned, okay, and replaced by this Tawinder Singh, right? So, but this Ravindran was not called to testify. Okay, so that means during the trial, only Tawinder Singh was called to testify. So he testified that the signature on the cover letter was not Ravindran's signature, but that is the story of DW1, not the story of Ravindran. Okay, so according to the best evidence rule, this is not the best evidence rule, because if you say Ravindran's, whether this is signature of Ravindran, you should call Ravindran his or his not signature. Okay, so although Ravi and Kalai Selvi was removed as directors of the first defendant, okay, pursuant to court order, okay, they were appointed in 2016, but later pursuant to a court order, they were removed as directors in 2018 in June lah. Okay, and the DW2 is second another director, okay, and Govindan, okay, they were removed as directors before replaced by this Ravi and Kalai Selvi. So now remove Ravi and Kalai Selvi, replace them back. That means they are reappointed back as directors of the first defendant. Okay, but although okay, these two Ravi and Kalai Selvi were removed, okay, but their name, okay, Ravi and Kalai Selvi were on record as directors of the first defendant during the period in between, right? That means in appointment in 2016 until June 2018, their name were on the record as the first defendant's director. So it's also important to note that the court order did not, all acts by this Ravi and Kalai Selvi were to be declared null and void. Okay. Challenge, okay, the common seal. Okay, our directors, you never challenge the common seal is not authorized, the common seal is not theirs, the companies. Okay, so the question is, how could common seal be affixed on the sale and purchase if it's not authorized by the first defendant? That's the question, right? So in this reference, the court referred to section 64 of the Companies Act, which says, okay, company contracts, okay, a contract may be made by a company in writing under its common seal. Okay, you can refer to section 64 of the Act. So the first defendant had never claimed, okay, they did not authorize the common seal, or the common seal was stolen, did not belong to the first defendant, nothing of that sort, right? Okay. Okay, so in effect, what the court is trying to say that the SPA's validity still complies with section 64, it's still a valid contract, okay? Okay, the second evidence is the original title to the land, the piece of land, okay? The land was kept by the second defendant. Remember the second defendant who acted for the first defendant, okay, on September 2007, okay, before the SPA was signed, together with appointment letter from D1. So how could the original title have been delivered to the second defendant if the first defendant had never authorized it? So that's the question, okay? So if the sale and purchase is not valid, then why the first defendant has never inquired where is the original title of the land? Okay, why was there no police report? If it was lost, it was stolen, okay, or it's misplaced, why was there no police report of the original title being lost or stolen? Okay, that's the question. Okay, and then evidence number 3, employment pass. Remember Kalai Selvi, okay, is the national of India. He's not a Malaysian citizen. So she needs employment pass to enter. So in the employment pass, it was stated as, okay, as for employment as manufacturing director with Tasker Transmission Malaysia Sdn Berhad. So there must be a nexus, okay, relation between Kalai Selvi and the first defendant. Okay, so there's possibility here, balance of probability that the first defendant intended to appoint Kalai Selvi as director of the first defendant. Okay, so all this on balance of probability. And this evidence number 4, okay, after lodgement, okay, of the document with the SSM. So SSM notified the first defendant. Okay, they noticed that there's a change of directors. So SSM notified first defendant, okay, the company itself. But there's no evidence that the first defendant inquired about the change of directorship. They're just silent. Nothing, no response from them. Until a year later, okay, only the company COSAC of the first defendant wrote to the SSM to make a complaint. Okay, if these two directors, Ravi and Kalai Selvi, were designed to fraud this land, okay, or dispose this land fraudulently from the first defendant, they wouldn't have to wait so long, right? They were appointed in 2016, okay, about 1 year then to act, to sign this S&P, okay? Because the longer you were there, the higher the risk of being exposed, right? So that's the issue, yeah. So this Ravi and Kalai Selvi has been named as directors of the first defendant at the material time when searches were conducted. Okay, so as we know, records at SSM would prima facie evidence, okay, to the world that the name directors, okay, the director's name in the SSM records were correctly represented by the company. Okay, so a third party, okay, who's outsider, has only a minimum duty to carry out inquiry of their legitimacy of the appointment. They do not have further whether the appointment. So there's nothing here further, there's nothing here that could raise any suspicion for the plaintiff to make further inquiry, okay, for relating the appointments of Ravi and Kalai Selvi. This is more important, okay? Both parties are represented. Both parties, especially the plaintiff solicitor, has already performed their professional duty. They already make all the relevant searches, okay, title search, okay, they have already do, okay, SSM search, they have already do. Okay, so what is that rule before I go further, okay? When you come across this, what is the rule that we have learned before, okay, regarding this? You want to try answer? No one? Okay. Okay, let's just continue, right? Okay, this is the Tekkan's rule, okay, or what we call indoor management rule. It derived its name from the case of Royal British Bank against Tekkan. Okay, what is this rule about? Okay, what's the story of this case lah? It was a manager, okay, official manager of companies incorporated under the Joint Stock Companies Act. So the company gave a bond for £2,000, okay, to the bank, the plaintiff bank, Royal British Bank, to secure the company's drawings on the current account. So when the company was sued, it was alleged that under its articles of association, actually the directors had only power to borrow up to a certain amount authorized by the company. So a resolution had been passed, but not specify how much the directors could borrow. So the court ruled that the bond was valid, okay, because Royal British Bank, okay, is an outsider, okay, it's a bona fide outsider dealing with the this company, okay. So the bond was valid, so that the Royal British Bank could enforce the same. Okay, the bank was deemed to be aware of the directors that could borrow only up to a certain amount. Okay, articles of association were registered, but the ordinary resolution was not. Okay, it's not registrable under the UK law. Okay, so the court there in that case held that the bond was valid because there was no requirement, okay, for the bank, for the Royal British Bank to look into the company's internal workings. So that's what meant by internal management rule. Okay, outsider will be assuming that, okay, if the whoever person who signed or who borrowed, they will have the necessary power according to their constitution or M&A to deal with third parties. Okay, that was the principle. That was what we call Turkan's principle. Okay, this principle was laid down to facilitate business dealings as a person dealing with the company in good faith. Okay, it's entitled to assume that the company's internal affairs is regular. Okay, so that's the principle of that rule. Okay. So therefore, it requires a party who intends to deal with a company to do the least minimum. Okay, that's the least minimum. Okay, and you are entitled to rely, okay, on information as provided under the search. That's the bare minimum that an outsider needs to do. Okay, so the duty of the first, in fact, okay, is the first defendant's duty and director's duty to ensure whatever records in the SSM are updated. It's their duty to update the records, okay, with the SSM. And the information as provided by the SSM are accurate and correct. Okay, if it's not correct, or if there's any discrepancy between, it is their obligation to make it correct, not the outsider's obligation to have notice. Okay, so that's the principle of that. Okay, another evidence that the court finds is that even though Ravi and Kalaiselvi has been removed by directors, okay, as directors by court order in 2018, that removal as directors does not mean that their appointment were unlawful. Okay, in fact, okay, in that application by the two other directors who were later reappointed, okay, DW2 and Govindan, they filed this, okay, but this Ravi and Kalaiselvi were not named as the respondent in their application. So actually, when they removed this, Ravi and Kalaiselvi were not given any response, not given any chance to hear their story. Okay, so that's the story. Okay, so in this case, the court, okay, after hearing the evidence and finding the facts, evidence submissions from the parties, the court allowed the plaintiff's claim and ordered the cost of 30,000 to be paid, okay, by the first defendant to the plaintiff. Okay, that's the facts of this case. Any question you want to raise about this? Any clarification? Let me see. Okay.
Any question
Yes.
from the audience? Joa? Or any others?
No, not for me. But Bowie, we can actually, the rules actually set by the court is actually, we as a lawyer or the public, actually we can rely on the SSM search report as a prima facie or as the up-to-date record, and we have no further obligation to actually go into again to check the details whether it's updated or the info is updated or not. So this is the rule set by the court, right?
Yeah, and I mean under the Tekans rule, the Tekans rule is still applicable. Okay, and don't forget there is another rule in, I mean another section provision relating to this. Okay, when we talk about Tekans rule, then the rules of constructive notice will come into place. Remember the amendment to the Companies Act in 2016, section 39 has removed this requirement. Remove these requirements means outsider dealing with parties, dealing with the company, a company is not required, is no longer required to have constructive notice of the internal workings of the, of the company. Okay, actually the concept is, the rationale is we need to understand why. Okay, because if the company requires constructive notice, okay, as in the old 1965 Companies Act, okay, parties are required to have constructive notice, okay, especially on the M&A, the powers of directors, okay, because they are public documents. But now in under 2016, parties outsider is no longer required to have constructive notice, because the rationale is that it's like this. Because if a person, because the reason is that they want to simplify dealing with companies, right? That's the whole purpose of the amendment to 2016 Companies Act. So if parties are required to have constructive notice, you imagine how burdensome. That means I want to sign an SPA, I have to not only make a search, I have to dig all the documents, the form 49, 24, or 44, or M&A, have to read all, then only I can sign, or you have to rely on all this, then only you can sign. So it's a troublesome, it's make transaction with the company more troublesome. So that's why under section 39 of the Companies Act, it has removed all this requirement. No need to have constructive notice, but the principle is that you at least must do the bare minimum. This case say you must at least do the bare minimum, which is at least must be a company search lah. If you even company search also didn't do, that's very hard to justify already lah.
Okay, thank you, Bowie.
Can
Thank you.
Okay. So any other clarification want to seek? Okay. If not, okay. Since we are sharing this with the case update from time, on quite regular basis, right? So we should perhaps have rotate among ourselves. For the corporate NDR team, or maybe corporate team, to produce an article or produce case update, just like how the real estate do for their clients lah. Okay. I can also participate, be in the rotation list. Okay. Maybe I can start with the case update on this case, this Shen Tet case. Okay. And then we will rotate, okay, including all the partners in the CC team. Is that okay? Because I think it's also important to keep our clients updated, not only ourselves, our clients also. And when they ask questions or what, then we can clarify with them. So we can also explain, advise them. Okay, it's actually both sides, win-win for both sides. Okay, should we do that? I will come up with the rotation list.
For you, the rotation list between this CC and DR, let them come up with that. Let this Manchan and Yuwa, let them do the rotation list.
Okay. Or let them do the rotation list. Okay.
Yeah, let them do it. Let them discuss among themselves.
Okay. All right. Is there any other question apart from this? So is there any questions? Any further questions? No. Okay. If not, then I thank you for attending. Okay. Thank you for all the participation. Okay. Then I see you again. Thank you.
Okay, bye.
Thank you, Bowie.
Thanks, Boy.